Assalamualaikum warahmatullahi wabarakatuh. To everyone, good day as well to those who are non-Muslims. Yeah. Now, what I'm going to prepare this is how to answer this question. But this method is actually more towards answering questions by non-law students, because for non-law students, what is important to them is for them to understand the law and also how to apply the law in that particular question. Now look at this question. Maju Berhad is a manufacturing company and owns all the issued share capital of Nusa Sdn Berhad, an electrical goods retailing company. So the board of Nusa Sdn Berhad consists of 3 directors who also form part of the board of Maju Berhad. Nusa Sdn Berhad is in liquidation with the result that its unsecured creditors will not be paid. So basically, probably there are some unpaid creditors, unpaid debts to creditors. So, and probably what's left is the unpaid creditors. So advise whether Maju Berhad as a shareholder, because they own all the shares, can be forced to contribute to the settlement of the debts of Nusa Sdn Berhad. Okay, let me just highlight this part to make it clearer that that's the question. So in order for us to understand how to answer this question, you need to understand what is the issue first. What is the issue? The issue is whether Maju Berhad as a shareholder can be forced to contribute to the settlement, okay, of the debts of Nusa Sdn Berhad. Okay, this should be okay. Okay, the issue is whether Maju Berhad as a shareholder can be forced to contribute to the settlement of the debts of Nusa Sdn Berhad. Now, I'll still be using issue, law, application and conclusion, but this is the method that I'll be using, that for every law that I put it in, I straight away apply to the question. Yeah, so I start off with introduction, and most of the time I will start off with something on company. Okay, because we are talking about a company being a separate legal entity. We have done that topic last week. So this is the one, section 14 provides a person who desires to form a company shall apply for incorporation to the registrar. And in fact, a company shall not, pursuant to the same section 14 as well, companies are not companies shall not be formed for any companies, okay, and the company shall not be formed for any unlawful purpose. Okay, this is just the way I put it in introduction. Now, why did I put this kind of introduction? Because I just wanted to prove that Nusa Sdn Berhad and Maju Berhad are lawful companies. Okay, since the what do you call that, the business, okay, the business of Maju Berhad and Nusa Sdn Berhad are the businesses. Okay, this is the business, the type, okay, the type of business of Maju Berhad ni, okay, the types, manufacturing, okay, manufacturing company, manufacturing and electrical goods retailing, okay, manufacturing company, okay, manufacturing company and electrical goods and retailing company, okay. respectively. Okay, both are lawful business and can continue. Okay, a lawful business and they are subject. Okay, and the companies and the companies are subject to CA 2016. Okay. Now, what I will highlight to you now, when you start off introducing Companies Act, okay, Companies Act 2016, and you want to use abbreviation of CA, you must introduce Companies Act 2016 first, then in bracket CA 2016, so that the next part can straight away use CA 2016. Now, I would like you to use this introduction first, because CA 2016 CA can also mean Contracts Act. So try to be more specific. Yeah? So you introduce Companies Act 2016, then in bracket CA 2016. So this is how I introduce the introduction part. Okay. Since the types of business of Maju Berhad Nusa Berhad and manufacturing, okay, both are lawful business and the companies are subject to, okay. Why they are subject to company CA 2016? Because they are registered under that particular act. And then after that, what we need to discuss now, we know that Nusa Berhad, okay, and Maju Berhad, they are interrelated, I suppose, because Maju Berhad are the shareholders. Okay, Maju Berhad are the shareholders. At this juncture, my students, I have not introduced you on wholly owned subsidiary. But the sentence, Maju Berhad is a manufacturing company and owns all the issued share, meaning to say that Nusa Sdn Bhd is a wholly owned subsidiary of Maju Berhad. Okay, you can define here. Okay, section. Okay, section 6. Okay, section 6 of the CA 2016. Defines wholly owned subsidiary corporation, wholly owned subsidiary corporation as a corporation okay, wholly owned subsidiary means a corporation which has no members except this is wrong. Section 6 define wholly owned subsidiary, or we put it the other way around. Okay, it's not defined. Section 6 provides that a corporation is a wholly owned subsidiary of another if it has no member except that other corporation or its nominee, or a wholly owned of that other corporation. Okay, so what do we call that? A wholly owned subsidiary, meaning that they don't have any other members except one corporation, except that other. O-T-H-E-R. Okay. Okay. A corporation is a wholly owned subsidiary if it has no members except that other corporation or is a nominee or a wholly owned subsidiary of that other corporation. Meaning to say, Nusrat Sdn Bhd, okay, does not have any members, okay, except Maju Berhad, which is a corporation, and that particular corporation owns all the issued share capital. Why do we need this? Because it relates back to our question. So section 6 provides that a corporation is a wholly owned subsidiary of another corporation if it has no members. Or you can put another way around. If the company only has one corporation, only has one member, which is a corporation. Okay. And then based on the definition, based on the definition of section 6, okay, based on the definition of section 6 of the CA 2016, we can say that Nusrat Sdn Bhd is a wholly owned subsidiary of Maju Berhad. Okay, Maju BHD. Now, if you see that particular sentence, okay, this is the issue. Only one issue for this question. This is the law, right? Okay, and this is the application. Now, I still did the same thing. Issue, which is just one issue. Law, okay, I put in law here as well. Okay, and then this is the application. Okay, so same thing. I move on to the next one, which is wholly owned subsidiary. This part I would like to tell that electrical goods retailing company, manufacturing company is a lawful business, and this one I would like to explain that on the issue of wholly owned subsidiary. Okay, what next? Okay, what do we need to know next? Okay, if possible, we'll have to discuss separate legal entity, correct? A company cannot ask its shareholders to pay all the debts. Is it correct? We have done that. The moment a company is incorporated, the veil is actually dropped down to what happened? Drop down to separate the members from its shareholders. And what does it mean by that? It shows that they have the separate and they are separate entity. They have own legal assets and liabilities. Yeah. So we can put in section 20. Section 20, or you can straight away of the CA 2016. Okay. Okay, when we want to introduce section 20 section 20, we're going to introduce particularly section 20 subsection 1, which stipulates that a company incorporated under CA 2016 is a body corporate and shall have legal personality separate from that of its members. Okay, that is very important. And then we can further explain that this doctrine of separate legal entity, okay, which is the legal personality separate. So this doctrine of separate legal entity is derived from the case of Salomon and Salomon and Company Limited. So I would like all of you to actually try to highlight or bold or underline your case to make it separate, so that you can know that from afar that you actually have cited a case to substantiate your argument. So this doctrine of separate legal entity is derived from the case of Salomon and Salomon. Okay, and then you give in the a bit of the facts, and then you give the decision. So hence, the company that have separate legal entity means that the shareholders are not liable for the debts of the company. So it further means that, okay, see this part? It further indicates that Nusrat Sdn Bhd is a separate entity from Maju Berhad, and basically Maju Berhad cannot be made liable for the debts of Nusrat Sdn Bhd. Okay, That is the first part. But do you really think? Okay, if we look at our statement here, we have decided because based on separate legal entity, Maju Berhad cannot be made liable for the debts of Nusa Sdn Berhad. And in fact, we need to know this rule, that this is the rule. Let me just, okay. It is a general rule that each company within a group is a separate legal entity. Holding company and its subsidiary are distinct legal entities. Thus, holding company cannot be made liable for the acts of his subsidiary and vice versa. So this can be seen in the case of People Insurance and the People Insurance Company Limited. Now, this particular case you can find you can be found in my book. As of now, I expect you to understand that each companies in a holding group, they are distinct. They have their own separate legal entity. So what this case talks about is that court found that company is separate from its subsidiary company. A company cannot be made liable or responsible for the debts or action of another company within the group. Thus, the debts of the company belongs to itself. Okay, and if we look further, however, can you make your members liable? Can you actually make your members liable? You can also argue further, however, right? There are circumstances where the members can be made liable. So in order to determine the liability of the members, okay, the court will lift the veil of the company. Okay, you can see the case of Hotel Jayapuri, which you have seen yesterday. So what happened here is actually the court lift the veil of both companies, and we also, for our purpose, you can also just lift the veil of Nusa Sdn Berhad, to identify who are the shareholders of the company. You can also leave Maju Berhad, but the way I see it here, we just need to leave the veil of the Nusa Berhad to see who are the shareholders. So based on the problematic question, Maju Berhad own all the issued shares of Nusa Sdn Berhad. It can be concluded that Nusa Sdn Berhad is a wholly owned subsidiary, wholly owned subsidiary of Maju Berhad. And this concluded, and this has been concluded earlier based on the definition of Section 6 of Companies Act 2016. Thus, both Nusa Sdn Berhad and Maju Berhad can be treated as a single entity. Okay. Now, what next? Okay. So when the court decided, if we were to follow Hotel Jayapuri, okay, basically the court can lift the veil, and Maju Berhad as a shareholder, they can actually pay for the settlement of the debt. So if we follow Hotel Jayapuri, once we lift the veil, both Nusa Sdn Berhad and Maju Berhad can be treated as a single entity. So this is your conclusion. This is your conclusion. Okay, so thus, based on the decision of Hotel Jayapuri and National Union of Hotel, and since Nusa Sdn Berhad is a wholly owned subsidiary of Maju Berhad, okay, so the latter, which is Maju Berhad, can be made liable, okay, can be made liable to the settlement of the Nusa Sdn Berhad, okay. Nusa Sdn Berhad's debt. So this is how you answer this whole question, because this is separate. This is very special because it's a wholly owned manufacturing company. Nusa Sdn Berhad is a wholly owned by Maju Berhad. Now, I'm sure student will ask me, Madam, how is it that if we just stop here? Okay, we stop until this case, holding company cannot be made liable for the acts of his subsidiary and vice versa. Okay, because you are relying on this case. So it all depends. This is a general rule. Basically, they are separate legal entities. They cannot be made liable. But these are the general rule. So you have to ask yourself, is there an exception to the general rule? Can the court lift the veil? Okay, because you have done lifting corporate veil, so that's why you also need to know, okay, circumstances where the veil can be lifted. So, yes, court can lift the veil following the case of Jayapuri. It's a wholly owned subsidiary. Yes, they can be made liable. So thus both Nusrat Sdn Bhd and Maju Berhad can be treated as single entity. So based on that decision, Maju Berhad can be made liable for settlement. So this is how you answer this question.